All right. Go to law school, study estate planning for 5+ years, go through all the tax regulations, and then you can have an honest discussion with the estate planning attorneys on this thread who know what they're doing. Comparing attorneys is tough. I've got some strong, highly conflicted, and self-interested views on this, so please be cautious with this guidance. I am loosely describing how I practice, but I generally make it a rule not to solicit business with this account so as to remain objective. Estate planning requires forward-facing attorneys who enjoy working with people. Personality is very important, and you generally want someone who you feel comfortable speaking with, not just someone with amazing credentials. I am also a strong believer in being accessible for questions all throughout the process, and I know full well that no one gets all their questions asked and answered during an initial consult. To that end, I and roughly half the estate planning community tend to prefer quoting a flat fee and not varying from it except in rare occasions. It creates a tremendous amount of comfort in both client and attorney to be able to put together an estate plan over a period of a few weeks and just not have to worry about hourly billing along the way. That's a bit of a controversial one, and in no way do I mean to deride my hourly peers. Beyond that, I think I once posted a list of questions to ask when interviewing/comparing estate planning attorneys. Let me see if I can find it. So that actually touches on this flat fee versus charging by the hour. And for me and my firm, I do flat rate. This is what it is. And we have different packages for some of these situations. Just the estate plan with a trust plus if you really have to get into protecting another generation from lawsuits and divorcing spouses and other stuff. And then we have a kind of premier, which is lawsuit shields and irrevocable trusts and all that other stuff. So yeah, there's different levels of pricing, but we kind of stick to it. There are a lot of other attorneys that will sit down, run through it, and then they quote a specific flat rate price for that particular client, for that particular situation, and they just do that throughout without some standardized pricing system, and that's all fine too. But the point is, if you're initially, it's just price, that could be a problem. So let's see. There aren't any surveys, just stories passed around lawyers. But most estate lawyers, if they're serious about the answer, would say that maybe 2% of DIY wills go seriously wrong, maybe more. Lawyer-written wills and trusts, on the other hand, have a rate less than 0.1%, usually because the family just wants to fight, not because the lawyer's wording was in error. If you have $1 million estate and give out 2%, risk is $20,000. Of course, you're not going to be around when the yelling starts. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channels. Good point. Oof, I don't know where that 2% is coming from, but I'm going to hazard a guess that number is a lot higher. Relatedly, I just took over estate planning for a surviving spouse whose husband's estate tax return might have created a $400,000 tax bill she and the Department of Revenue blessedly had no idea about. Does that fall in the 2% or the 98% bucket? Depends. Do you call 400,000 serious? All right, so I'd say that's pretty serious money. Let's keep going. We're getting near the end here. Define go wrong. The incidence of wills found disastrously wrong is low. Usually it's a dead or poor choice of executor. The incidence of trust going wrong in one way or another is extremely high. Disastrously wrong, I don't know. I think the heirs usually just shred it. Beneficiary designations can also go horribly wrong. Yeah, I'd put the odds of making at least a minor mistake in planning, funding, or drafting a trust at near 100%. Lawyers don't even bat 90%. Okay. You're definitely mischaracterizing the risk. While you're right that attorneys only interact with DIY trusts when they go wrong, The risk of something going wrong is not 0.001%. I genuinely think the chances of needing some attorney cleanup is closer to 25 to 50%. I'd say that's probably right, just because I've seen how dramatically a plan can blow up. And I've got a couple of videos of exactly that, where a client, quote, had the plan, paid for it throughout, and then just decided, well, or we don't have a lot of money to spend on this. We'll just do our own amendment. And they used some phrasing from a will. And what they ended up doing qualified as a holographic will, where they completely revoked their trust and all the planning we did. And the only thing they did in the will was leave a certain thing to go to someone else. But it was set up to pay into the trust that they just revoked. They just created a huge, huge mess just by writing it out and it having qualified as a will. The chances of something going seriously wrong is probably 5 to 10%. These things seem straightforward, but they are easy to mess up, and you won't be aware if you have made a mistake or missed something until you are gone. You don't get a do-over. The relatively slim chance of a major mess up, triggering probate, for example, can be significant when you consider that probates can easily cost an estate tens of thousands of dollars. Depending on how much more you pay for the attorney's help, I think the math actually pencils out financially in terms of quantifiable risk avoidance. Not to mention the intangible peace of mind you brought up and the fact that a good attorney can help you consider factors you might not be aware of. Again, it's the attorney knows what they're doing. Their job isn't to provide you documents. It's to provide you peace of mind and a plan that's going to work once you're gone. By asking this question to a bunch of estate planning attorneys, you're of course going to get self-serving responses. Well, self-serving, I think they're honest. But if you ask the question, I think you owe it to yourself and the people responding to genuinely consider the responses. As far as I know, no one is actually seeking your business. You're getting the responses because the mess-ups are ubiquitous. Another poster. It's not often that I see an online or DIY estate plan come into my office after the death of the testator settler, because at some point, most of those people either see a lawyer and have a well-drafted estate plan, or all of their assets are held with right of survivorship or by beneficiary designation, so the deficiencies in their estate planning documents never come to light or make a difference. But there are a few more examples from my career. One, decedent had a self-drafted will. It was properly witnessed but failed to waive bond for the personal representative. Despite requests in the petition for probate, court denies waiver of bond and personal representative must obtain one. The cost of the bond is close to what such a simple will would have cost had an attorney prepared it with the bond waiver provision. So who thinks about bond waivers other than estate planning attorneys? And getting that bond cost what a will being done by an attorney would have cost. Right there, that's all the savings. 2, decedent was advised to avoid probate at all costs and so transferred her house to her daughters during lifetime. She then had a legal Zoom will where she devised her IRA to 5 individuals in equal shares. 2 problems. First, she had inherited her house with more than 40 years prior to her death with a ridiculously low basis, so I had to advise my clients to move into the house and live there for 2 years to avoid a huge capital gains hit. She then had a long, protracted legal battle with her sister over the maintenance of the house during that 2-year period. Second, the IRA had beneficiary designations and wasn't governed by the will, but when a small estate affidavit was filed, my client's sister found out about the devise of the IRA and raised hell with my client, the named beneficiary of the IRA. My client ended up cashing out a portion of the IRA just to get her sister off her back, and of course took the income tax hit on that. 3. Decedent had a self-drafted will. It was not properly witnessed. This was the mistake I see most often, and thus was not effective as a will. The intended beneficiary of his estate was a step-nephew, someone not his heir, who thought he'd inherited the decedent's house. We've had to file an action to quiet title through adverse possession to clear title to the house, tracking down heirs in other states, and spending about what a properly drafted will and probate would have cost. Number 1 and 3 are cases from just this year alone. When you have a lawyer prepare your estate plan, you're not just paying for someone to fill out forms. You are paying for the knowledge and expertise to understand what the best plan is for you and your intended beneficiaries. I am mentoring a second-year associate, and she is preparing her first revocable living trust for clients with a state taxable estate. She has been drafting simple estate plans and reviewing other attorneys' documents for the last year and still commented on how different and challenging it is to be working with the form and applying its provisions to her client's facts. It's just not as easy as so many people perceive it. Why is the 6-year-old scenario so challenging? All right, so now we're actually getting into some major tax rule changes that happened at the very end of 2019 and to the point where the regulations are only starting to come out, and we're kind of in late 2022. Traditional qualified retirement accounts, IRAs, 401ks, 403bs, etc., on their own generally require some extra care and attention already, as they ordinarily represent a pent-up income tax bill to a beneficiary, unlike most other assets. Congress just radically shortened the time frame to pay income taxes on inherited IRAs beginning 2020, requiring even more income tax care with qualified retirement accounts at death. Regulations governing that law were not even proposed until the middle of this year, and they represent an unexpected departure from what most every professional expected. Those regulations are, of course, not even final and likely have more changes yet to come. At the exact same time as those income tax implications and unexpected regulations are hitting, we're now also running into tremendous procedural complexity in having named minor beneficiaries. Even that minor's custodial parent or guardian is struggling to accept a designated qualified retirement account on their minor child's behalf. Charles Schwab earlier this year made me get a court order naming a minor child's mom and dad as the custodian of the IRA left to that minor child by his grandfather. Something most people, including the decedent, thought would happen automatically. I ended up charging several $1,000s for something we all understood should never have been needed to be done. So much for quick and painless, like beneficiary designations were meant to be. So nowadays, most professionals are doing everything they can to avoid naming a minor child outright, preferring instead to name a trust for the benefit of a child, whether created by the account holder's will or living trust. Except that this now implicates the first point: trusts are taxed not just at the absolute worst possible income tax rates, but now fall victim to the quickest income tax escalation on the tax-deferred qualified retirement account. In many ways, we're now trading tax savings for structure and often losing on both ends. It's incumbent now on estate planning attorneys to be responsible. Okay, so there's just a ton of stuff there on inheriting retirement accounts under these new rules and regulations. It's just a lot, and people don't understand the complexities, just the same way that this poster has no idea about the estate planning implications of it. This kind of like diverted from this poster's questions to explain a much more complex area of income tax, inherited income tax law. Middle-class parents are just trying to make sure their minor kids are protected, and I'm here basically teaching a effing tax seminar about a 5-figure retirement account. Can you tell my clams are steamed? You don't know what you don't know. Years or decades from now, you may discover what you don't know now. Fixing the problem in the future may be much more difficult and costly than preventing it now. Definitely, definitely true. In the original poster, I am trying to have an honest discussion, and this is not a helpful response. Thanks for telling I don't know what I don't know. All right. Go to law school, study estate planning for 5+ years, go through all the tax regulations, and then you can have an honest discussion with the estate planning attorneys on this thread who know what they're doing. And they're just telling you, look, you don't know what you don't know. And that's what's going to affect your estate if you try to do it yourself. And he's just like, yeah, whatever. Then don't ask the question. This is actually the most helpful response you could receive. You think you can do a lawyer's job and save some money. Go for it. When it turns out you made a huge mistake, you'll be dead, so no need to save face. Seems like you came here just to argue. Not all lawyers like to argue, especially will and estate lawyers. 100%. We're here because we enjoy the planning part of it, the preventing problems from happening. And it's the do-it-yourselfers who don't know what they're doing when the plan blows up that it has to get cleaned up. And then that just gets into these other areas of law that we don't enjoy. A divorce court, that's cleaning up a marriage mess. Medical malpractice, a doctor screwed up and now you're having to sue. It's just all of this. It's the cleaning up messes that a lot of areas of law have to handle, but wills and trusts and estates don't. It's about planning ahead, except when you're doing probate and you're, quote, cleaning things up. You seem to have made up your mind already, so maybe I'm wasting my time. Yes, an estate planning attorney, I am arguably biased. But as someone who has zero chance of making money off of you and doing your estate planning, you should probably take the well-meaning advice of experienced estate attorneys. You shouldn't pay $10,000 unless you have a lot of complex issues. But there is a very good chance that paying $2,500 to $5,000 will ultimately save you or your beneficiaries many, many times that in the long run. We've all seen it dozens of times. The most salient observation that has already been made is one you wrongly dismissed. You don't know what you don't know. Another commenter here noted that the price you pay is almost always for the counsel. Ferreting out issues related to your assets or beneficiaries through consultation that you aren't experienced or educated enough to identify. It's not a slight on you, but there are some instances in which a single word in a trust makes a lot of difference. E.g., a lot of attorneys use the health, education, maintenance, and support standard in their trusts, but in some states, support tends to be excluded because there is a case law suggesting that it can be interpreted to mean child support, which creates an asset protection problem. But ultimately, all of this is too abstract to overcome your entrenched objections. If you want more insightful responses, you shouldn't provide purely hypothetical details about your simple situation, your assets, relationships, intended beneficiaries, and then tell us what the trust you would do online would say. Then the estate planning attorneys on this post could provide more concrete, but of course purely hypothetical, answers regarding how they would do things differently. So yeah, it's the original question is, why shouldn't I just do it? My case is simple, but then they didn't explain what their situation was at all. My brother did his online, forgot to include his home in the trust. Claim on the estate, we could lose $700,000 equity because that portion is in probate. Okay. Agreeing with everyone else, with everyone above, and I will also say that some of our most messy / lucrative for our firm probates have been for non-estate planning attorneys doing their own estate planning. I mean, they took the class in law school. How hard could it be? There are a lot of interesting issues with estate planning and you generally have multiple options, but those options have trade-offs that are not necessarily clear to the layperson. Just boiling it down, look, you don't know what you don't know, and it does come back to bite you. Many times the standard language in the DIY documents is not the problem. The problem is the stuff people who don't know anything about property law try to do and put in is often extremely stupid and doesn't work. It ends up not being worth the paper it is written on. It's a penny smart and pound foolish situation. And another one, you can absolutely do it yourself, but if you plan on just going to a random website and doing a trust and a will, you will probably F it up. Go to the library, get Estate Planning for Dummies, read it through, and then go to an online site and make your plan. That is the only post so far out of all those posts that says, yeah, sure, go ahead and do it, but study some more. No, it's just not going to work. So here was my response. I read through all of the comments so far, and I compare and boil things down to a fictional post. Parent has a sick kid diagnosed with appendicitis. Parent: hey, r/surgery. Why should I pay a surgeon to remove my kid's appendix? I can get the same surgical knife through Amazon, and I have a book on how to do an appendectomy. Reddit: don't do that. You're very likely to screw it up and kill your kid. Get an experienced surgeon to do it. Parent: but the surgical knife is the exact same one surgeons use, right? And the book on how to do the surgery is accurate, right? I don't see what I'm getting from a surgeon that's any different, and surgery is a lot more expensive than the knife in the book. Reddit: look, we've seen this crap go wrong, and people end up rushing their kid to the hospital, and the ER bill is far worse than the original surgery. We have a lot of personal knowledge and experience in this. Don't do it. Parent: you're not answering my questions on whether or not the surgical knife is the same and whether or not the book on appendectomies is accurate. I still don't see why I shouldn't save money doing it myself. Reddit: I'm a trauma surgeon. It's absolutely stunning how much more money I can make handling a case to try to save a child's life when their parent tries to save money by cutting their own kid open because they didn't want to pay a surgeon as opposed to paying the general surgeon in the first place. Parent: yeah, I keep hearing that from you Reddit surgeons, but you're still not answering my questions about the knife, the book, and why I can't just do this myself. Reddit: in 95% of cases, we have seen the child die from the parent trying to do surgery. 4.99% of cases, the child lives but has an extremely high hospital bill from having to be rushed to surgery. Parent: so you're acknowledging that it could be successfully done in 0.01% of cases, so the surgical knife is the same and the book is accurate. Reddit: sigh. The only real difference between this fictitious thread and this one is that it is illegal for non-licensed people to do surgery, and it is the potential death of a person on the line and not just screwing up an estate. And at least half of the DIY wills or trusts I've personally reviewed with people wanting a, quote, second opinion, either the documents dramatically don't do what they thought they were doing, or they aren't even signed or witnessed correctly, making them invalid. A lot of experienced attorneys here have told you what an absolutely horrible idea do-it-yourself website estate planning is, what a ridiculously high rate of failure it has, how much more money attorneys make cleaning up these messes after someone dies, and you're ignoring all of this because you want a philosophical discussion on boilerplate language. Just go buy the knife then. And I gave him the link to buy the surgical knife off of Amazon. All right. It is ridiculously high rate of failure, and you don't know what you don't know. But it just comes down to this particular person. They're going to do what they want. There's no logical reasoning behind it when they've made up their mind that they want to save money, and now they actually went to r/estate planning, not for advice, but for absolution. They were just looking for someone to tell them, yeah, it's the same, it's fine. So this video is already ridiculously long. I'm sure we're going to break it into parts, so I might as well tell the story. Many years ago, and I mean many, many years ago, when I actually had an ad in the Yellow Pages, if you remember back then, I ended up getting a call from a woman, totally not in what I was saying I was doing in my practice. She wanted to know if she could marry her boyfriend. And so she went through the situation, and they were getting, they'd been dating for a while. They wanted to get married. And, there were a lot of older people that they weren't approving of it. But then she found out it was her half brother, because her father was actually also his father. You can't marry your brother. But we're not going to have kids. You can't marry your brother. But the only people who know, who are alive, they're really old, and they're not going to be around much longer. You can't marry your brother. But, we didn't know when we fell in love, and so you can't marry your brother. And it was going on for like 15 minutes because I just wanted to wait until she actually acknowledged, no, she can't marry your brother. Thing is, this woman was about 40 minutes away. I'm pretty sure she called every single attorney between me and her, trying to get an attorney to say, yeah, it's fine. No, it's illegal to marry your brother. She was looking for the answer she wanted to hear, not the one that was true. And she would have gone through every single attorney in the state until she got the answer she wanted. It's not accurate. It's not helpful. It's not true. But she already made up her mind. And I think this is where the original poster was coming from. So, all right. So if you really want to check out good estate planning, there's my book, Estate Planning Basics Book, at estateplanningbasicsbook.com. And there's also the audiobook version at estateplanningbasicsaudiobook.com. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.